Our next case is Iowa Individual Health Benefit Reinsurance Association versus State University of Iowa, Iowa State University, and University of Northern Iowa. And it looks like the parties are ready to go. Ms. Register, you may begin.
Can I have more than a minute and a half? Thanks.
You had to use my time that I was talking. That came off yours.
May it please the court, counsel. Good morning. My name is Tessa Register, and I represent the Regents institutions of University of Iowa, Iowa State, and University of Northern Iowa. So prior to the Affordable Care Act, if there were individuals who were hard to insure or prohibitively expensive to insure, it was largely left to the states to figure out how to get these folks meaningful, non-illusory health care coverage. And in the 80s and 90s, Iowa developed a two-prong approach. The first prong of that was we decided to enter the market ourselves. We created a nonprofit organization called ICHEA. For those at home, you might know it as HIP Iowa. Our cases use ICHEA, so that's what I'll use today. And so we decided to offer individual plans directly to Iowans ourselves who could not otherwise get coverage. That was the first prong of our approach. The second prong was we wanted to incentivize other people who could get in the game to get in the game. And we did that through a reinsurance association, that's a HIBRA. And the way a HIBRA works is that if you provide individual plans and the premiums you collect on those plans are insufficient to cover the claims you have to pay, a HIBRA will step in and cover the difference between 90% of your earned premium and the total claims that you owe. And so a quick example using lawyer math here, if you earn $100 in premiums and you have to pay $200 in claims, the way a HIBRA will work is we'll reinsure you for the difference between 90% of your premium, so $90, and the claims you owe, $200. And so a HIBRA will provide $110. You get $100 in premium. You owe $200 on the claim. You come out with 10% of that earned premium, the $10 ahead. That's the purpose of a HIBRA. And so it's a big and good incentive to cover these high-risk patients and offer these plans. And so the legislature included numerous entities within a HIBRA as a way to diffuse the blow of covering these claims. And the question today is whether the Regents institutions, who are 509A providers, are members of a HIBRA. And in my view, there are three barriers to finding that the Regents are members. The first barrier is the plain language within 513C 10(1)A, which does not include 509A providers. Yeah.
Benefit plans in this state and then including. I was staring at that thinking, how could they make that broader? Help me out. How is your client not part of that?
If there was a period after the word state, I think we'd be having a different conversation. But there's a whole lot of other language in there, and notably the catch-all. And the catch-all is other entities subject to state insurance regulation. And the elephant in the room in this statute is ERISA. There are health plans offered in this state that are not subject to state insurance regulation, namely ERISA. And so if that first category is as broad as a HIBRA wants it to be and as broad as all persons in this state, that would capture entities who aren't subject to state insurance regulation, and that would render the catch-all meaningless. And that's not how we read statutes. And so we have to read it so that every part does work. And so we have to read that. We can't read it as broadly as we want to. But looking at that first, yeah.
Insurance commissioner, if that entity chose, regulate these Regents self-funded health care plans?
So your question is, could the insurance commissioner, if it wanted to, regulate these plans?
Briefing, they haven't, but could they? Do they have statutory authority to regulate them? Are these plans subject to Iowa Insurance Regulatory Authority?
That we are not, and that when we look at insurance oversights, there's a difference and a sensible difference between the oversight on local schools, political subdivisions, and the oversight on the state. And that makes sense. If the city of Clive wants to offer a self-funded healthcare plan to its limited employees, that's going to cost a lot of money. And so the Insurance Commission, what they'll do under the rule, and I think it's 191-3520 that we're talking about, what they'll do is you'll say, at the end of the year, give me your financials. What are your premiums? What are your claims? And the Insurance Commission will look and make sure that you're not taking on too much risk. because we want to make sure these claims get paid. We want to make sure we have continuity of coverage for the employees here. And so both the state and the regions in particular are operating on such a different scale that that level of oversight is unnecessary, and the legislature has decided that that level of oversight is unnecessary. We are the largest employer in the state, so that's two things. We get the most employment lawsuits, and we get pretty good health care.
You talked about having to read the statute in a limited way because of ERISA plans. So can you give me an example of an ERISA plan for which this carve-out was intended?
An employer who offers their employees health plans through ERISA, that plan is not subject to state insurance regulation. And I read that catch-all as entities offering insurance or benefits subject to state insurance regulation. And so I think
A region institution plans subject to ERISA.
these are entirely self-funded. We do it on our own.
What would be an example of that kind of plan? So a private employer plan.
Is the one I'm thinking of. I think some companies use it. I'm sorry, I don't have a more specific answer than that. But that is, I think, and if you look at 513C11, the section right after, it talks about that. Hey, if you're a provider under ERISA and suddenly it becomes okay to enter this type of thing, to be subject to this type of state regulations, we want you in there. And so that's where we know that they're trying to exclude that. And I think it's really important. So that subject to insurance regulation language is not unique to 513C. When I was preparing for this argument, it actually appears several other places in the insurance chapters. And significantly, it appears together in statutes that also expressly reference and include 509A. And the most important one is 514L.1. That statute is the best comparator that we have here. 514L.1 tracks it almost identically. It has the first list of 509, 514, 514A. There's a comma, and that it includes a provider of a plan subject to 509A. And that it ends with the catch-all of other insurance benefits subject to state insurance regulation. And so that tells me two things. When they want us included in that first category, they know how to do it. They know how to add us in and group us in with 509, 514, and 514A. And the second thing it tells me is that we don't fall into that catch-all. If we fell into that catch-all in 514L.1, there would be no reason to add us separately in there.
Argument, you were discussing earlier about why, like, a city might be subject to oversight. Okay, is oversight the same thing as being subject to insurance regulation? Just because those two specific provisions that you rely on don't apply to the state or to the regions, does that mean that, does that necessarily take the regions completely out of state insurance regulation?
The way I've been thinking about it is subject to state insurance regulation is just an odd and unusual way to describe the state. And so that's not how we're normally referenced in code. And so I think, again, the purpose of that is to exclude things that are federally preempted. But what does it mean to be subject to regulation? I think it matters that it says subject to, that we are the receiving of the regulation. And 509A, I read as an enabling statute. I read it as a permission statute, right? When state agencies can only do what the legislature tells them to and gives them permission to do, I read 509A as giving permission. I don't read it as necessarily regulating an entity. When we think about regulated professions or regulated entities, that's usually not a permission statute or an enabling statute. And so that's where the kind of structural argument comes from, is that I have a hard time wrapping my head around an enabling legislation being considered a regulating statute. Yeah.
Just to be really blunt about Justice McDermott's question earlier, that because normally we would just read all persons that provide health benefit plans in the state, including, and then including would be just a list of examples and just be a non-exhaustive list. And that would be the ordinary way we would read it. So to get to your reading that these are sort of limiting, the examples there are actually limiting it. It has to be subject to state insurance regulation. We kind of have to walk away from that initial view. And ultimately then we have to read this statute without the words, persons that provide health benefit plans in the state including. So that really we just have to read it to say all insurers that blah, 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 blah. In other words, long story short, if we're going to find for you on this issue, do we have to just acknowledge that we're saying the words persons that provide health benefit plans in the state, including, are surplus? It's just, we're ignoring that language.
Do that. And I'll tell you where I want you to look. So 514C.12 is another example where it has that very same broad opening language, and it inserts 509A directly between 509 and 514. And so that tells me that the legislature, and it has that same word including in it. And so that example tells me that the legislature knows how to lump us in together, even when we're using broad inclusion language, and they know how to insert us into these things. So 514C.12 is a good example of this omission here being intentional. And it makes sense that this omission is intentional, because if you look at the second barrier here, which I think is 509A.5, 509A.5 limits the use of the health funds to only be used back into the fund. Region institutions, 509A providers can only use our health funds in a way that goes back into the program. We are statutorily prohibited from using them from external purposes. 509A.5 was in existence before AHIBRA was created. It was not amended at the time AHIBRA was created. It has not been touched since AHIBRA was created.
From my area of expertise, Ms. Register. So let me try and clarify a point you made earlier. Obviously, there are tons of state employees around the state and various different state entities, in addition to the region's institutions, which are part of the state. Do any of those other, and the state is self-insured and administered by, like my coverage is administered by Wellmark, but I'm self-insured, or the state is self-insured. For the purposes of all those other state entities, they don't participate in this reinsurance pool? Is that what you're saying, or they do?
That was not developed below. I believe there's a passing reference in AHIBRA's brief that the state used to be a member until very recently. That's the best I can give you. But it's our position, the region's position, is that 509A providers, which would be state entities, it would be DAS, it would be regions, are textually excluded. And so to the extent that they, until very recently, they recently pulled out, that would be consistent with our position, but it's just not in the record what other entities, 509A providers, are in there, and I'm sorry.
Record that indicates, at least at one point, the state was participating. There's like a spreadsheet, and it shows the assessment amount, and Iowa State and UNI.
Oh, for a while. Yeah.
Change in law that triggered that. So, I mean, it's possible they could participate. There's not federal preemption here because they were participating for a number of years.
Constitution prohibits it. That's a separate conversation. But two things there. One, I think past government entities should be encouraged to take a step back and reevaluate whether we're using.
Just a little bit. So you're saying the state of Iowa and two of the region's universities, under advice of counsel for more than a decade, were participating in a program that was preempted by federal law and is
Sorry. I'm saying they were not included in the Iowa statutes. We were not members in 513C 10(1)A. The federal preemption only comes in the subject to state regulation section. That's the only part of preemption that I'm talking about. I think that's the work that that section does. I don't think that is intended to capture the state. I think that's intended to exclude federally preempted providers. But to the extent that past practices, parties can't stipulate to the law. And so I don't think that a series of past practices could ever amount to some type of stipulation that the course of conduct met some legal standard.
So if Iowa State had said, we are members, we've read the statute, we believe we are members, we voluntarily paid our assessment, what part of the statute does that violate, that legal conclusion?
I think it violates 509A.5. I think it would be an improper use of funds. I think it's a misread of 513.10(1)A, in particular, given that 509A providers are included elsewhere in our insurance laws and in very similar structure to this statute. And I also think it would run afoul of Article 7, Section 1 of the Iowa Constitution.
Again, as I start with this, is there any other entity other than these three schools that wouldn't be subject to this? I mean, are they the sort of unicorn?
I think any other 509A provider would not be. And so a 509A provider is not just state entities, it's any partially publicly funded entity under 509A. And so, yeah. It could be Polk County if they offer self-funded plans. Any county could offer a self-funded plan if they wanted to, or any partially funded government entity. It would be a 509A provider. Anytime we're using public funds in there, which again kind of goes against our constitutional backstop, there's a good reason that we weren't included here.
This constitutional argument, because I want to test the breadth of it. Is it your position that if, let's say, the University of Iowa signs a bowl contract for a bowl game, and they agree to guarantee to the bowl that there'll be a certain number of seats purchased, is that an assumption of debts that violates Article 7, Section 1? Is that an unconstitutional agreement? Is that a position that Attorney General really wants to be taking here?
Our problem. I think 262.52 talks about self-liquidating entities, which would, I think, include our stadium. And we actually have special permission to do certain financial obligations or certain financial endeavors, fundraising endeavors, and separate from state funds. And the point there, I think, is I'm over my time. I'm going to finish if that's okay. Okay, thank you. The through line in a lot of the Article 7, Section 1 cases is express statutory language from the legislature that says, when you issue these bonds, when you engage in this endeavor, you are not using state funds. This is not a state debt. We see that in almost all of our Article 7, Section 1 cases. What's missing from 513, what's missing here is any acknowledgement from the legislature that they're running up against a debt and that they're thinking that state funds would be used for this purpose. And so so that goes to the Article 7 problem, which is I don't think they were meant to be included here. We don't have that type of reservation language when we're paying, using public funds to pay into a HIBRA.
A question on subject to state insurance regulation. So we know that municipalities are covered under the regs, under 3520, for the reasons you stated. Their concerns are smaller entities. The insurance commissioner wants to make sure that the risk is appropriate. Could the state or the insurance commissioner or the legislature by statute decide that it wanted the state plans also subject to the supervision of the insurance commissioner? Is there anything that prevents that? No. Okay. So does the word subject to mean actually subjected to regulation by the commissioner, or that's something that could be subject to regulation if the commissioner chose to do so?
Good question. I read it as, I think the best read is actually subject to state, because in that theory could be, I mean, ERISA could be upon a change in federal law. I think they're upon a change in statute, I think we could be, but I think the better reading is that entities that currently are subject to state insurance regulation.
Traditionally would use the word subject to, for example, you are subject to the jurisdiction of blah, 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 even if jurisdiction isn't actually being exercised over you at the time, right?
I think it could be at any time, which is untrue of the insurance commissioner in this situation. I'll say the rest on the reply. Thanks.
May it please the court, I'm Greg Lederer. I represent the Iowa Individual Health Benefit Reinsurance Association. With your permission, I'll call it the association. For better or worse, I am of the generation that was taught how to diagram sentences. And to take from the court the first question, all persons that provide health benefit plans in this state, if you diagram this sentence, you have to find the verb for that portion of the sentence. And you find it at shall be members of the association. Everything in between is the including part and other possibilities. But the legislature, when it enacted 513C.10 sub 1, sub A, decided to start by saying, if you provide health benefit plans in this state, you are a member of the association. The language including the standard take on the use of the word including in statutory construction is that what follows are examples that might otherwise not be considered to be included in the general statement. And the reason you include the word include and follow it with examples is so as to be sure that those things are part of the general description.
So for our private company self-funded plans included within that language? Yes. So what do you do with 513C.11 that says that those types of plans that are subject to ERISA, those private funded plans, can choose to be part of the plan or part of the program?
I don't know the answer to that. I don't have to know the answer to that respectfully today.
With respect to what 513C.10 means then?
It's an ambiguity with respect to these defendants. I don't. Because these are people who provide health benefit plans. They're not impacted by ERISA in any way, shape, or form. No one has ever said anything about ERISA in the long history of this case. Never. And the rest of the statute has not been the subject of discussion in this case. The question has always been, who is a member? The state argues that 509A is the source of its authority for a state university or any other governmental entity for providing health benefit plans. I agree with that. 509A sets forth the title, Group Insurance for Public Employees. 509 regulates group insurance, period. Together, the two of them provide the basis for anyone providing group insurance that covers health, including government employees. If you look at 509A, it is filled with state regulation of governmental bodies. Definition, governing body of 509A.11 means the executive council of the state, the school boards of school districts, the superintendent, or other person in charge of an institution supported in whole or in part by public funds. Public body means the state, a school district, or an institution supported in whole or in part by public funds. That's the definitional language for 509A. All of 509A applies to the regents and every other state entity that subsides below the state of Iowa. And while we're on the subject of the state of Iowa, the state of Iowa has been a participating member of the organization, of the association, since its inception until after the summary judgment in this case, after which they have declined to pay the assessments. They have declined to respond to the audit request. The University of Northern Iowa and Iowa State University for 15 years participated in the audits and paid the amounts that were assessed against them.
You look away regarding University of Iowa? I'm sorry? During that time, you're talking about Iowa State and UNI, did you look away regarding Iowa?
At that time, the University of Iowa contracted with a health insurance company that provided health insurance benefits.
Made a change there.
And the University of Iowa changed its business model and became a self-insured provider of health benefits, just like Iowa State and UNI. All three submitted responses to the assessment. This is the first
Time, any gap between that period of time when they were outside private insurance until self-funded? What period of time transpired?
It would have been one year they used private insurance policies like lots of folks do. The next year, they were self-funded.
Did you get involved with saying, hey, pay up?
For the 2010 calendar year, the association sent them a letter saying, it's come to our attention that you are now providing health benefits on a direct basis rather than through an insurance company.
Gap there?
Whatsoever. And University of Iowa did respond to the first audit request. And of course, Iowa State and UNI did as well.
Images for a minute. Number one, what kind of hearing was it? Was it a summary judgment hearing? Was it a stipulated trial? I mean, the procedure here is hard to define for me.
Question. I submitted an accountant-based calculation of all of the amounts, yes, that were to be assessed against the three universities. It was reviewed by counsel, and there was stipulation that these were the amounts that were assessed and that were owed pursuant to the summary judgment.
So what was it then? I mean, if we're looking at this damages award, is this cross motions for summary judgment? Is this a bench trial subject to substantial evidence review? What are we looking at?
Summary judgment, the district court overruled and denied the Regents University's motion for summary judgment, granted the association's motion for summary judgment. Thereafter, I submitted to opposing counsel the accounting-based assessment for each year for each university, and they stipulated to those numbers. There was no hearing with any witness testifying.
So on this sheet, then you have the stipulated assessment amounts, correct? Going from 2010 through 2017. And then the late fee here, which your accountant calculated at 5%, that is something different than the 1.5% interest. Is that right?
He used an erroneous number of 5% as opposed to 1.5% per month. The universities benefited from the error, the amount, but there's not a separate amount. The late fees under the plan of operation for the association permits them to charge 1.5% per month for late fees. Correct. We charged them, by mistake, only 5% per annum. So the number for the late fees is less than it could have been.
Oh.
Stipulated.
Lederer, let's say we find that the late fee was not contracted for. Let's say we end up agreeing with you on the merits, but we find the late fee was not contracted for. Don't you still get statutory interest from the date of filing and maybe interest on each year from the date when that year became liquidated, because those are liquidated amounts?
Thought about that. I've been...
Is you got nothing, and that seems odd for, normally, when you win a lawsuit, at least you get interest on the award back to the date of filing.
Certainly get interest on judgment, but we've haven't got to that point yet.
I want to go back to this 5%. And this is what's troubling me. I understand the plan document says that there's 1.5% interest per month. You decide to go ahead and try the damages case by submitting this document. The document on its face says late fee. So we don't have testimony about what this fee is, what it represents. You say it was a mistake. I don't know, because no witness testified to it. So how are we supposed to review a fee, which you just say, well, at the time of trial, we just kind of made up a number, and that's what it is?
Respectfully, I don't think you need to, because it was stipulated by the universities that that was the amount. There was no argument that
It was 5%. I don't think they argue, I don't think they stipulated it was right to impose a 5% fee. So they didn't stipulate to it.
that relates to. Yes. And, but their argument is that our plan of operation that provides that we may charge a late fee of 1.5% per month does not apply to them.
An agreement to charge, and an agreement is more than some plan that you have in a cabinet in your client's office. It has to be an agreement that's been communicated to the other side, right?
Not agree that the association and any particular member have to reach an agreement on what the late charge will be. The legislature commanded that the association be governed by a board of directors, and they are to prepare and operate under a plan of operation. That plan of operation, which has been passed by the board of directors, provides for a 1.5% late fee per month, 1.5% per month.
Was that communicated to the Regents universities?
It's communicated to all members in the assessment letter that goes out.
Are the assessment letters, other than the first one, in the record?
So
This is a proof issue. So if you want to impose a 1.5% assessment and you come to trial, let's just say this was a trial, like actual bench trial or a jury trial, and you claim we want 1.5% late fees per year after each assessment, and then you don't put the assessment letters in the record, so that shows that they knew of the assessment, that they had notice of the assessment, then there would be insufficient evidence in support of damages. So I'm really struggling just by putting this document in the record when there's no evidence of notice, there's no evidence of the right fee, the late fee, it's 1.5%, not 5%. I understand your position is that's less. How are we supposed to evaluate that on this record?
if I did not get a stipulation, we would have had a damage hearing, and I would have presented presumably more evidence. I did not need to because we had a stipulation that the amount was this. And they simply did not believe that they were obligated to pay it. And to me, that is a legal issue. My time is up.
Stipulation in the record, just so I can reference it. Where in the record is the stipulation, the actual language, so I can reference it?
I believe that it is in my submission of the accounting documents. So that would have been a filing with the court before the entry of judgment. On behalf of the association, I asked the court to grant the reversal on our cross appeal for the 1.5% interest on late charge and the expensive litigation. I asked that the court affirm with respect to the assessments against the regents. Thank you.
I think I want to go back to where we spent most of our time, which is 513C10. I think the doctrine of statutory construction that gets us the furthest here is exclusion by omission. I really want to emphasize 514L.1 and 514C.12. Again, that tells us the legislature knew how to include 509A providers in schemes just like this, in statutes that look just like this, that have the same kind of nightmare paragraph just like this, and they know how to do it, and they didn't do it here. And I think that's the best argument. I think that's the path of least resistance. And I think we have an interest in interpreting all of our insurance chapters the same, so that the same language carries the same meaning. And so I think it's important that if you look outside of these chapters, at the neighboring chapters, 509A appears a lot, and we don't appear here. And it makes sense that we don't appear here because it would violate 509A.5 to use our funds this way, and it runs uncomfortably close, if not passing the constitutional line. And so we shouldn't read the statute that way either.
Back to the area that I was talking about with Mr. Lederer, trying to figure out if there's a gap at all. But you represent the regions, not just one of the three. And two are playing ball, one's independent, and then the other one doesn't. And now all of a sudden, when they join the fracas, you say, oh, we're not members. But those two schools have been operating as members for quite some time. So help me understand the change of heart.
They were reading the statute incorrectly, but we were reading the statute incorrectly. Thank you. Thank you.
Well,
We were reading the statute incorrectly before. We took a step back and said, is this a proper use of state funds? And I think that's government conduct that should be encouraged. I really struggle with state entities doing something wrong and spending money they shouldn't for a period of time and having that held against them when they decide to spend money correctly. I don't think, and again, as a legal matter, parties can't stipulate to legal conclusions, and I don't think a course of conduct could ever rise to a stipulation that it was proper before. To which...
In years, apparently the state and the Regents universities read the statute the same way that Mr. Lederer reads it, right?
Any further in your doctrines of statutory construction. I don't think past party conduct helps you understand the plain.
You've said long-standing administrative constructions and things like that. That's not relevant, at least. I'm not saying it's dispositive.
For 13 years, between 1997 and 2010, the two of the Regents institutions were participating. From 2010 to 2023, they're not. We've got 13 years now of different conduct.
13 years. This litigation has been going on for most of those 13 years. How about legislative acquiescence? Has the legislature done anything to step in and address this?
In fact, what the legislature did just this past term in 2023 is they enacted 514.12a, which is a brand new statute that does the exact same thing. It adds 509A to the list of providers. It adds us right between 509 and 514 in another insurance statute. And so just this past term, the legislature knows how to expressly add us if they want to. They've never gone back and added us to 513.10, and they never amended 509A.5.
Spring sand versus unnamed local government risk pool. Or fourth point, the state auditor's historical treatment of ICAP, the acronym, is informative. So we relied on the fact that for a long period of time, they didn't try to audit it, that was relevant in deciding whether they had the power to.
Yeah, but I mean, whose statute is it, I guess, in the auditor's statute? I still think party conduct is of minimal, if any, probative value. And I think the plain language here, and particularly the plain language coupled with other nearly identical plain language, has to carry the day. Yeah.
You don't dispute that the state stipulated to the amounts in the spreadsheet?
I read the record is that we stipulated to the actual assessments that would have been assessed from 2010 to 2017. I read the record as having a bench trial. There was a trial brief. The parties filed trial briefs. That's what I read on ours. And then the district court made a decision. We disputed in that trial brief heavily that late fees were appropriate and whether 5% could be anything. And we disputed that heavily.
Okay, so there's a bench trial, maybe.
Decision issued.
That's a fair assessment. So that was my assessment. So where does that leave us in terms of reviewing a damages award when you don't really have a trial, you don't really have a summary judgment? We don't have an explanation relating to the document, and it's not clear what the party stipulated to.
The conclusion where you're left is that the party asking for damages did not meet their burden to prove those damages. I think that's the conclusion we're left with here, is that there was insufficient record. I think that
And do we need? We've got the plan documents. I mean, what if we had a hypothetical trial and there was no stipulation? What's missing from this record? You're either legally obligated to pay a late fee, or this assessment scheme has no enforcement mechanism. You could ignore it without penalty, which doesn't make sense. So, if we send it back for trial, what evidence are you looking for?
in my view, there's two problems with what happened below. One, the legal availability of late fees at all, which to me I read as kind of a backdoor way to get attorney's fees in. But the second problem is the fact that the late fees they asked for were unauthorized. They're not in code and they're not in the plan. They came from nowhere. And so when it was up to them and it was put up time, the number they came from, even if you agree that 504 nonprofits can generally operate pursuant to agreements, and that 513, the limitations on what funds in 513 they ask for, which is a more specific statute, doesn't trump that general statute, even if we get that far.
1.5% a month or 18% a year, isn't that in the plan?
But that's not what they asked the district court for, which leaves us in this limbo of, and I think their position is, well, you're welcome, but we have to have legally cognizable damages here, and it's not based in plan, it's not based in code, and that leaves us nowhere, and that's what the district court decided.
Larger amount, asked for less, isn't that good enough?
Talking about this was not an equitable remedy the court constructed here. This is something they thought they were quasi-contractually or contractually owed, and they didn't ask for what the agreement provided or what the plan provided, and I think that matters.
I'm looking at the transcript from this hearing, and this is the state's lawyer. Greg is correct that there's no real dispute on the amounts of the assessments. We have talked. He has given us a copy of the Exhibit 1 before today's hearing and before he submitted it to the court. And so we accept that the amounts of the assessments are what should be imposed to reach a final judgment and move forward with the case. That doesn't indicate that the state, at least as I read that the state was objecting to the 5% late fee that was being charged. Am I misreading this?
Together with our positions before that, which was in the trial brief. And so I drew a line between the assessments and the late fees. And so I read that language as we agree on what the assessment is, and I agree on the actual money here, what we would have paid in that 7-year period, and we didn't dispute that, and that's how I read it. But if you look at our trial brief, separate from that assessment fund, we did strongly object to the number that they asked for in late fees. If any other questions, I'd ask that you, okay. No, you're fine.
You agree that the question of interest is governed by 535, Chapter 535?
In front of me, I do know there are limits on assessing pre-judgment interest against the state. I would ask that post-judgment interest, if anything, but I also think it's probably the obligation of the party to ask for the damages they get. And I don't remember ever seeing a request for interest of any kind, pre-judgment or post-judgment, down below. And I don't recall that interest award being given by the district court. And so I don't know that there hasn't been an ask to up that damages award on this appeal. And so I think it's the person asking for the money has to ask for what they want. They didn't ask for any type of interest. I certainly wouldn't agree to prejudgment interest. And I think that part of the district court, if you affirm the summary judgment, I think that part of the district court on the assessment has to be left alone.
It's something to Justice Waterman when he cited the Sand case. You said, well, that was a different statute. But it also says, we recognize that no claim of estoppel can lie against the government. However, the state auditor's historical treatment of ICAP is informative. You may have two different statutes at issue, but you got one court, right? Yeah, and so, go ahead. So if you'd address that.
I didn't mean to answer that it's a different statute, so we'd interpret it differently. My answer was more that whatever probative value that the regents have in performing under a statute that they don't administer, I think it is minimal, if any, and even then, I think we'd only get to that type of statutory inquiry if we found the language to be ambiguous when looking both at the language and elsewhere where that same language is used. I just don't see us ever reaching that inquiry because I think the language here and elsewhere forecloses that. Thank you.
Case of Iowa Individual Health Benefit Reinsurance Association versus Iowa State University, Iowa University, and UNI is hereby submitted, and court is adjourned for the afternoon. Thank you.